Welcome to the Supreme Court of the United Kingdom. This morning, the court is handing down judgment in the appeal between Mastercard Incorporated and others and Mr. Hugh Merricks CBE. I will now provide a short summary of the court's decision. This appeal is about collective proceedings for the pursuit of claims for damages for breach of competition law. Where unlawful anti-competitive behaviour is alleged to have caused loss to large numbers of consumers, the Competition Act 1998, as amended in 2015, enables a representative to bring collective proceedings on behalf of the whole class of the consumers who are said to have suffered loss. And the claimant may seek aggregate damages, that is, the amount representing the loss suffered by the class as a whole, without having to work out how much loss each individual member of the class has suffered. If the claim succeeds, then the damages are distributed among the class in whatever fair way the representative proposes and the court or tribunal approves. Collective proceedings are Parliament's answer to the practical problem that the loss typically suffered by any single consumer from anti-competitive behaviour, which may be only a few £100s, will usually be insufficient to make it sensible for one consumer to bring a claim alone in a fight against a major player in the market, because such claims usually involve complicated economic issues, calling for the deployment of expensive research and expert evidence. If, however, the proceedings can be brought on behalf of the whole class of alleged victims, then the greatly increased potential value of the claims may make the large investment in the litigation worthwhile and more likely to attract the necessary funding. In this way, collective proceedings secure access to justice for the vindication of the rights of consumers, and the availability of this special form of procedure creates a powerful disincentive against anti-competitive conduct in the future. Collective proceedings for breach of competition law are likely to be very complex, protracted, and burdensome, both to the parties and to the legal system. Accordingly, Parliament has entrusted sole jurisdiction over such proceedings to the Competition Appeal Tribunal, which has unparalleled expertise in this specialist field. Collective proceedings must be started in the tribunal, and they cannot be pursued further unless and until they have been certified by the tribunal as fit to be pursued. Thus, the tribunal acts as a sort of expert gatekeeper in relation to collective proceedings of this kind. Certification requires the tribunal to be satisfied of two things. First, that it is just and reasonable for the proposed representative to represent the class. Secondly, that the claims are eligible for inclusion in collective proceedings. This second condition is satisfied only, A, if the claims raise common issues of law or fact, and B, if they are suitable to be brought in collective proceedings. One of the many factors relevant to suitability is whether the claims are suitable for an award of aggregate damages. The present proceedings are brought to seek redress for unlawful anti-competitive conduct by the well-known payment card company Mastercard. In 2007, the European Commission decided that Mastercard had, since 1992, been in continuous breach of competition law by setting excessive default fees for the use of its cards in payment schemes by which consumers made purchases of goods and services from retailers in one EU member state using cards issued in a different member state. Mr. Merricks began collective proceedings on behalf of all consumers who had bought goods and services from retailers using the Mastercard payment scheme, on the basis that the excessive default fees led to higher prices being charged to UK consumers by retailers in the UK. It is claimed that this caused loss to some 46.2 million consumers over the relevant 15-year period. Although the typical consumer is likely to have suffered damage of no more than a few £100s, the total of the alleged losses for which aggregate damages are sought, is said to run to billions of pounds. Mastercard accepts, as it has to, that it acted in breach of competition law as found by the Commission, but it denies that this caused any loss at all to UK consumers. Mr. Merricks sought certification of his proceedings from the tribunal, but it was refused. While the tribunal accepted that it was reasonable for him to be a representative of the class, and that the claims all raised one common issue, it found that the claims were not suitable to be brought in collective proceedings. This was because, first, the claims were not considered to be suitable for aggregate damages, and secondly, because Mr. Merrick's proposals for distribution of any damages did not pay proper regard to the common law principle that damages should be fair compensation for each claimant's individual loss. I'll call that the compensatory principle. The first of those reasons was mainly based on the tribunal's perception that Mr. Merricks had failed to show that his method of quantifying the alleged loss would provide a sufficiently sound assessment of the true loss on the data likely to be available for examination at trial. The Court of Appeal allowed Mr. Merrick's appeal against the tribunal's refusal of certification on the ground that the tribunal had made a number of errors of law, and it ordered that the certification question be reconsidered by the tribunal on a legally correct basis. Mastercard appealed to this court, seeking to have the tribunal's refusal of certification restored. The hearing of this appeal was presided over by my late friend and colleague Lord Kerr, who very sadly died 10 days ago, very shortly before this decision was due to be handed down. But he had fully participated in the court's deliberation and made up his mind about the outcome before he retired at the end of September this year, and the court's judgments were in final form before he died. But for his untimely death, this court would have dismissed Mastercard's appeal by a majority of 3-2, since Lord Kerr had already communicated his agreement with my leading judgment, with which Lord Thomas also agrees. Lord Sales and Lord Leggett would have dissented. Where a member of an appeal panel becomes unable to continue as part of it, the Constitutional Reform Act 2005 provides means whereby the panel can be reconstituted. As President of the Supreme Court, Lord Reid directed that the panel be reconstituted following Lord Kerr's death, so as to consist of its 4 remaining members. But that would, if Lord Sales and Lord Leggett had continued to dissent, have led to an evenly divided panel and the need for a rehearing before a differently constituted panel at great expense and causative of serious delay. It would not have been a just outcome. In the exceptional circumstances where Lord Kerr died so shortly before judgment was to be handed down, having already expressed his settled opinion about the matters in issue, and where the judgments were in final form before his death, Lord Sales and Lord Leggett have therefore also decided that this appeal should be dismissed, so as to give effect to the opinion of what would have been a 3-2 majority, while maintaining their disagreement with the reasoning in my judgment. My main reasons are in bare outline as follows. Although the tribunal has a wide discretion whether or not to certify collective proceedings, and although its expertise in this field should be respected, it made 5 errors of law in its appraisal of that question. First, the tribunal's weighing of the pros and cons of certification was undermined by its having failed to appreciate the breadth of the common issues disclosed by the claims. In fact, as has now been determined, both the central issues are common issues. That should have been a powerful factor in favour of certification. Secondly, the tribunal was wrong to treat the question whether the claims were suitable for aggregate damages as if it was a hurdle which Mr. Merricks had to surmount, rather than just one of a number of relevant considerations. Thirdly, the tribunal treated the question of the suitability of the claims for collective proceedings as an abstract question, instead of asking whether the underlying claims would be more or less suitably pursued by collective proceedings than by individual actions for damages brought by consumers in the ordinary way. Individual actions brought by each consumer were plainly not a realistic alternative to collective proceedings. Fourthly, the tribunal did not take into account the long-settled principle of civil procedure that if a claimant has a realistically arguable claim to have suffered some loss from a breach of duty, then the court is obliged to allow the claim to go to trial, and then, if some loss is proved, to quantify that loss, however difficult the task, and must do the best it can with the evidence available. A trial cannot be refused merely because the quantifying the loss may be very difficult. This was the most important error of all. And lastly, the tribunal was wrong in principle to regard the compensatory principle as an essential part of the process of distribution of damages in collective proceedings, because Parliament had expressly provided otherwise in the legislation providing for collective proceedings. In their joint judgment, Lord Sales and Lord Legate agree with the majority about the last of those points, but otherwise consider that the tribunal made no error of law in its assessment that the claims were not suitable for collective proceedings. In their view, therefore, the tribunal's decision to refuse certification should be respected on that separate ground. Nonetheless, for the reasons already explained, the appeal is dismissed, and the tribunal will therefore need to decide again whether Mr. Merricks' collective proceedings should be certified. The court is now adjourned.